above my
There we go.
head. Oh,
You're there.
wow, look at that.
Perfect.
Great.
We can see you.
Great. Okay.
Can everybody see Jonathan when he's talking?
Yes.
Okay,
Yes.
great.
All right.
Okay.
So Sue, we're going to talk a bit about estate planning, right? So,
Yes.
And so what I thought I'd do would be, a lot of people put off getting their wills, powers of attorney and done because it seems like it's an overwhelming problem. There's so much to think about, and it's kind of scary. So some of you are probably hugely organized, but lots of people do this at the last minute. They're calling me from an airport and they got a piece of paper and they're trying to do a will. Well, they're trying to text me something, and then they say to me, Jonathan, if the plane goes down, is this going to work? And I have to say, unfortunately, no, it's not going to work. But I'm no better. I used to do a lot of these talks, and I'd ask everybody put up their hands if they didn't have a will, and I'd have to put up my own hand at the same time. I think the first time we did a will was we had 2 kids at that stage, and we were going away to England and leaving one of the kids. So I actually did a will, I think, the night before.
He did,
so,
the lawyer, big old guy.
So it's not like I'm holier than thou on this. I'm probably worse than everybody else. So maybe, like, estate planning really has a whole lot of aspects to it, but let's start off with what you've got to think about if you're going to do a will or powers of attorney. So we got this little form, and deliberately I try to make it as easy as possible, because I know some lawyers have got a 17-page form and it scares the daylights out of you and you never end up getting it done. So the main thing is to get it done. And really there's a few main things. Really, you want to make sure that you're looking after your partner, because that's the most likely thing, is that you one of you will pass away and leave the other. The the probability, excuse me, of both going down at the same time is pretty slim. So big thing generally is looking after each other. So let's think about what you need to know to do a will. The first thing when you do a will, the first question we have on our list is, who are you going to use as an executor? And an executor is the person who signs all the documents. They're the one who decides for selling the house. They're the one who signs the deal for the house. They deal with the bank. They clean out the house. They sign up for your funeral. So it's a really happy job being an executor. And what you try to do with that is hopefully get somebody with some business sense. And my bias, of course, is you'd leave your partner as the executor. But if there's a bunch of kids, my bias is to put all of the kids on. And the reason you do that is if you put one on and leave the others off, the one that's left doing the job is just going to take all kinds of abuse. Why is it taking so long? Where's my money? You sold this too cheap. You shouldn't have given this away, right? You should have got money for all the old clothes. Pretty rotten job. Whereas if all of your kids are executors, then they're all in the soup together, and one of them doesn't end up getting blamed for everything. So typically what happens is that you will name your surviving spouse as the main executor, and then you'll have alternative executors so that if your spouse predeceases you or loses their faculties, they can't do it or they don't want to do it, then you'll have a backup, which is alternative executors. And typically, if you do have a partner, that's when the kids kick in as being the alternative executors. And I mean, you'll put somebody up as executor, and if you name 4 kids and you've got 2 who move to Australia, they can simply sign off that they don't want to be the executor. So you don't absolutely have to do it. You can decide that you don't want to do it. And all of the executors have to sign everything. So if you've got 3 executors, you can't get by with just 2 of them signing and say, oh, 2 out of 3 ain't bad. You've got to have all of the executors sign. So it can be quite an onerous job. There was some of you probably saw it. There was an article in the Globe and Mail over the weekend as to what a crap job it is to be an executor, and basically telling you how to say no. Because one of the other things you're involved in with is finalizing the taxes, the income tax, and that can take a long time. So it's funny, the sequence. You get somebody somebody dies, and the executor will say to me, "Oh, Jonathan, George was such a good friend. He looked after me so well. He had me to his cottage every summer. I couldn't possibly charge for being an executor, so I'm not going to charge." And then after they've been doing it for a few months and they're frustrated, they say to me, "Jonathan, if I were to take executors' fees, how much would they be?" And then I'll tell them, "Oh, it's 2.5% on the money coming in and 2.5% on the money going out. So basically it's 5%. And then they'll look very wise and they'll say, "Oh, okay." And then a few months later, they come to me and say, "Jonathan, this has really been a lot more work than I thought it was going to be. So I think I'm going to take the money." And then another few months comes by. It's, when can I take the money? Do we have to get a court order? Do we have to get signed off? When can I get my executor's fees? So it's onerous. You can take a fair bit of criticism from the beneficiaries. Just not a fun job being an executor. Then once you've decided who your victim is to be your executor, you're then going to decide what you want to do with the money. And this is kind of an interesting thing, because and it's kind of a difficult concept, because you and I are under the delusion that it's our money and we can do what we want with it. Our kids, on the other hand, once we reach a certain age, basically they look at it as being their money, and they're just waiting for us to kick off so they get it. So they're pretty aggressive in their minds to make sure that the disposition of the estate is what they think is fair. Okay, so it's what they think is fair, which is, and I kind of learned this early on in my practice, they think everybody should get equal amounts of money. I remember the first time that it hit me was these people kept bragging about their son, who was a vice president of the Royal Bank, I think a fairly senior vice president. He had this huge house and he was so successful, et cetera, et cetera, et cetera. And then they've got a daughter who, she'd had umpteen relationships. She had a whole bunch of children. And, the fathers weren't very forthcoming with money. So she was broke and she just really had a hard life. So they decide that they're going to leave the vast majority of their estate to the daughter. And then they died, and the son, who was the vice president of the Royal Bank, was totally livid. He was beside himself that he wasn't getting the same as his sister. He thought it was totally unfair. He thought that it showed that they loved the sister more than they loved him, that they were rewarding the sister for, the wasteful life that she'd gone off and had a good time while he worked his butt off, gone to university, went up in the bank. And that is a common ongoing theme, is if you do anything other than leave everything equally between your kids, that there's going to be a whole lot of pushback at the end of the day. So our thought that this hard-earned money is ours is, as far as our kids are concerned, it's a delusion. And some of them, they figured out how much money they're going to get when we kick off, and so they live a lifestyle based on, well, when dad finally gets out of the way and stops wasting our inheritance by staying in a fancy old folks home, how much money are we going to have? When are we going to get it? And so they'll take loans, they'll take mortgages, all based on, okay, dad, when he dies, is going to be worth $3 million. There's three of us, we're going to get $1 million each. So it doesn't really matter now. We'll spend some money because we know when dad dies. So if dad screws them over and leaves the money to the Toronto General Hospital or the Knox Presbyterian Church or anywhere other than them, they're really upset. So it's and another thing with that is, don't give your kids copies of the wills. Like, just keep them. I had one where guy was getting remarried, and he insisted on giving a copy of the will to his kids, and one of them had gone on title to help him get a mortgage on a pretty valuable building, and she demanded $250,000. And this was a few years ago. The wedding was set up, and the new wife basically said to him, "I'm not marrying you if you've got all these fights going on." So he ended up having to give the daughter $250,000, and because he's doing a new will, leaving everything to, or leaving the vast majority to his new wife. So you really want to be confidential with the wills. Don't tell anybody what's in it. Don't give them a copy of it. Just keep it, excuse me, at the lawyer's office. So typically you'll leave everything to each other if you've got a spouse or a partner or a common law spouse or for tax reasons, because let's say you under the Tax Act, you're deemed to have sold everything the day before you died. So if you've got Apple stock that, excuse me, you paid $100,000 for, and now it's worth $2 million, you're gonna if you die, you're going to trigger a 1.9 million dollar capital gain, which will be taxable. The difference between what you paid for it, the 100,000 and the 2 million it's worth now. But if you leave it to a spouse, then there's no immediate tax. So, and then what happens when the spouse dies? Then if it's worth $3 million when the spouse dies, the tax is from the $3 million right down to the 100,000 that you paid for it. So you would be then paying tax based on $2.9 million, but it defers the tax. It would be the same with cottage properties or investment properties, that you delay the tax by giving it to, if it goes to a spouse. So you'll have a main beneficiary, which is normally the spouse, unless, and you've got problems there too, because what happens if you leave everything to your lovely wife? She gets the $5 million or whatever, and then she goes off and marries the pool boy before you're cold in the ground. Then you're worried. So if you're worried about that, then the pool boy could end up with all your money and your kids get nothing. So you have to worry about stuff like that. And sometimes if there's a home, for instance, you'll have it held in trust for your surviving spouse, and then when the surviving spouse dies, the money, or the house is sold, the money's divided up amongst your children. So you have to think about those kinds of things. And then typically after the spouse dies, then, or if your spouse predeceases you, you're going to leave it to your kids. And typically what you do there is you leave it equally amongst your kids, with a proviso that if your kid predeceases you and has children, his or her share would end up going to the grandchildren. So you very seldom leave anything to the in-laws. You tend to keep it within the family, within the bloodline, because if you leave something to your daughter-in-law because your son has died, you never know what she's going to do with the money. Your grandchildren may never see that money. So anyway, yeah, it's on a case-by-case basis, but you kind of think out all of these things. And just as an aside, when you're doing a will, you tend not to talk about individual things. So you don't say, I leave my 2020 Maserati to my son George, because when you die, you may not still own the 2020 Maserati. So you don't tend, or I leave the money in my Royal Bank account number 123568, whatever the case may be, to my daughter Mary. You don't tend to do those things with specifics. What you tend to do is you say, okay, I'm going to divide the residue of my estate, I'm going to divide it up 4 ways. And then if that then means that whatever you've got left at the end of the day gets split up 4 ways, because you might live a long time and waste it all at Aviva or some fancy home where they take $8,000 a month off you, and it depletes the money in the estate. So you don't really know what's going to be there. So you tend to do, wherever possible, you're going to tend to do percentages. So even if you're leaving money to a charity, you'll leave like 10% to your church, and then 10% to the Humane Society, and then you'll leave the rest equally between your children. So you don't tend to use actual figures or specific assets. Not an issue that we have to deal with at this stage, but there's also a proviso generally in a will. If you have small children under 18, you'll appoint a guardian. So that's another layer of complexity, which thank goodness at our stage in life we don't have to deal with. We don't have to worry about people looking after their. We don't have to worry about people looking after the children or the dogs. I had one client leave somebody $100,000 to look after their dogs. Actually, there is only one dog. So people do strange things sometimes with pets. So that's kind of the will. Now the will only kicks in after you die. So you can't exercise any authority over somebody's estate based on the will until that person has passed away. So
Jonathan,
yeah.
I have a question. I met somebody this summer, and they had a mother pass away at a fairly young age and inherited the house. But they had not gone through the legal process. I didn't know anything about it.
Right.
So what happens, like if my mother passes away, what do I do first?
So here's the problem. You have a will, and it's got witnesses and signatures and so on. But with a lot of assets in the estate, you actually have to get what's called a certificate of appointment of estate trustee. So that is basically the court charging a whole lot of money to give you so the lawyer has to fill in a whole bunch of forms and type up a bunch of documents for the court to sign, and then there's a fee of 1.5% of the value of the estate, and then at the end of the day, there's this piece of paper with a gold seal on the front and a signature, and and it has the will behind it. That's called a certificate of appointment of estate trustee. So, and there are some exceptions, but they're few and far between. But if you want to sell real estate and it's only in one person's name and that person dies, you have to go through this process, which is applying to get this certificate of appointment of estate trustee with a will. And typically it takes somewhere between 2 months and 6 months. And it all depends how busy the court is. So you have to make this application to court, and it has to be the court where the jurisdiction where the person died.
Okay.
So if you hear that the court in Toronto is horrible, it's taking 6 months, but if you go to Barrie, they're putting them through in 2 weeks. You can't go to Barrie. You can only go to the place where the person died or where they lived at the time of death. So you can't go.
Is that Ontario? Is that certificate of appointment of is that Ontario specific, or is it a federal thing?
It's Ontario specific, and worse than that, it's specific to the jurisdiction where the person died. So it would be Toronto, it would be Durham, it would be Wellington County, it would be, so it's the particular county where the person died is the court you'd have to go to.
Thank you. Yeah.
And there's no excuse that it takes that long. It's just that the people in the courts, you know, they work 9 to 5. They take breaks. And the attitude, if you listen to the judges and the clerks, the attitude is if Mr. Ford or it doesn't give us enough people to process this quickly, well, talk to Mr. Ford, don't talk to us. Like, it's not our fault. There's inadequate resources. So if there's a big lineup, like it's the court's fault, it's not ours. So that's called certificate of appointment of a state trustee. And you can't sell a property typically without that. And the banks typically won't let you at the money without it either. So if it's not a joint account, they're all a law unto themselves. Some of them have a $40,000 limit. Some of them, they don't know who you are. They'll make you, however much money's in your account, they'll make you, in the account, they'll make you get the certificate of appointment of a state trustee. So it slows the whole thing down. So let's quickly tell you what happens if you don't have a will. So if you don't have a will, there's what we call the Intestacy Rules. And so basically the Intestacy Rules are if you die with no will and you have a spouse and no children, it all goes to your spouse. If you have a spouse but you do have children, then the spouse gets the first $200,000 and then the rest is divided up between the spouse and the kids. So if you're a 40-year-old man, and as we know, men are immortal, like we don't like to get wills done because it's a waste of money, we're not going to die anyway. So he dies and he's worth $10 million and he's got a 4-year-old, a 2-year-old, and a 6-year-old, then mom is going to get, or his wife's going to get 200,000, and then the other 9.8 million is going to be split 4 ways. And then the government's going to get involved with respect to the to this large amount of money. So you're going to lose control of the money. So it's pretty important to have a will. The other fascinating thing, which is probably the biggest will seller I've ever seen, is that in order to qualify as being a spouse where there's no will, you actually have to be legally married. So if you're not legally married and you've lived with Frank for 20 years, but the house is in his name and all the bank accounts are in his name because he's kind of a controlling gentleman, and then you die, you got nothing. So the only thing you can do is make a claim saying, hey, I was dependent on my common law husband, so I deserve something. Or I worked my fingers to the bone while he sat home, drank beer on the couch and watched baseball games. So I paid off the mortgage, I should get something. But it's based on deserving something rather than the automatic of being married and then you get it. So pretty scary there. So what we try to do with these things is to have as little pass inside the estate as possible. So life insurance policies, you'll name somebody specific and then it doesn't pass through the estate. So it doesn't slow up the process with the estate, and you're not paying 1.5% on it. Same with RRSPs, because RRSPs are RRIFs, as you know, if you name your spouse as the beneficiary, they just flip over to the spouse. There's no immediate tax consequence. Bank accounts, if you could get them joint with a right of survivorship, then you don't have to wait for the certificate of appointment before dealing with them. So you want to do a bit of planning there. So then what happens when we do wills? We also encourage people to do powers of attorney at the same time. So there's two kinds of powers of attorney. One's the personal care power of attorney. And I call that one the pull the plug one, because that's the one that gives somebody the authority to make medical decisions for you. And when you do a power of attorney, you can have it in favor of just one person, or you can have it in favor of 2 or 3 people, or however many you want. And you can say, if you say it's joint and several, it means any one of those people can sign. So with a personal care power of attorney, you're hit by a truck, and your daughter's the power of attorney, and she's off on a cruise. You got a bit of a problem. So what you tend to do, or what I tend to tell people to do, is to have more than one, and then have it jointly and severally so that either of them can sign. So we do that. And then you always have an alternate, so that if one of them is predeceases or they're unable to act as a power of attorney, that somebody else can flip in. Then there's a second kind of power of attorney, which is a property power of attorney, which is for everything except the personal care. And with that, you'll tend that often you'll have the same person as your executor, and then you'll have a backup in case that person is unable to. And it's funny, it's a real pain not to have a power of attorney. Sometimes it's worse than not having a will. Because if you don't have a power of attorney and somebody gets to the stage where they could no longer sign, then you have to make an application to the government, which takes a long time. And you have to, the public guardian trustee's office, and you have to present them a plan, how you're going to how you're going to deal with everything. So we had a call last week where it's in 2 names. The lady is absolutely fine, but the husband is long gone Alzheimer's, and the question is, how can they sell it? They really can't. So a lot of the time, people just wait for somebody to die before they do that. Otherwise, they've got to go through this public guardian and trustee process. So it's pretty bad. So I think the moral of the story is that getting these things done is it's a good investment. My son does the wills and powers of attorney because for some reason people think he's going to be around longer than I am. I think for husband and wife or couple, whatever, the wills and the powers of attorney, it's something like $895, something in that range. And for an individual, it might be 500 or 595. So it's not necessarily a hugely expensive thing. And fortunately, he takes after his mother, so he's really efficient and disciplined. So he gets them done pretty quickly. But some others, you may well have other lawyers too. But it's don't be intimidated. It's not that bad. And what I tell people, if they're not quite sure as to what they want to do, it's usually down the line, sort of if your wife dies and all your kids die and all your grandchildren die, what are you going to do then? Well, think about that later, right? Because it's not that important. The question of that happening is very, very unusual. So what you want to do is put something down, because you can always change it. It's no big deal to change it. But get something in there that's got the most important stuff. And then, you know, we get some people that, some ladies come in pretty well every year after Christmas, depending on where they got invited and who talked to them. They'll cut out people from their will, so they'll add them in. It's the revenge after Christmas thing. So you can always change afterwards if somebody ticks you off. But pretty easy to do. Has anybody got any questions on those things? It's
How long would it take to get one done if I sat down and met with you?
well, when are you going off on the cruise, Sue?
First week in December.
Then no problem.
I'm good. Okay.
Yeah, I mean a few days. And with Malcolm, I mean, if somebody's in a bind, he'll often get it done super quick. He's very quick, and he does them himself. It's not like he puts them off on somebody to do them, and then he's so it's not a long process at all. Usually the process that it's virtually always the client that's slow because they can't decide exactly what they want to do.
And did I understand that the executors should be in Canada?
Yeah, because if they're, or at least one of them should be in Canada, because if they're not in Canada, in fact, some of the courts say if they're not in Ontario, then they'll ask for a bond to be posted. And the bond often is like twice the value of the estate. So hardly anybody can get the bond. But yes, that's a really good point. You want to have somebody in Ontario. Yeah, it's so.
Does anybody have any questions?
I just one quick question for Jonathan. If you have your will done in Ontario or your power of attorney done in Ontario and you move elsewhere to another province, do you have to recertify it or
You have to redo it?
Or is it
So
valid?
probably, I mean, I would say it's a good idea to do it. Because there is some variation between each province. So it's wills and powers of attorney aren't a federal jurisdiction, so that there are variations, but it's certainly better to have a will from or a power of attorney from another province than it is to have no will or power of attorney. So probably would work, but it would add complications. But most like the province with the most differences is Quebec. Quebec's got a totally different legal system,
Right.
Napoleonic code and all that stuff. So if you're going to Quebec, I would say definitely. And you bring up another good point is you can have multiple wills. So let's say let's say you've got properties or a property in Greece, for instance. You could have a will for your property everywhere else, and then a specific will that is restricted to your Greek property. And you'd do it in Greek, and you'd have it all done right for that jurisdiction, and you'd save yourself a whole lot of problems. So you can have more than one will, you just have to specify what it actually covers. So
Okay, thank you.
so there was one other little thing that I thought I'd talk to you about, which is something we're seeing all the time now. We're talking about estate planning, and we've got this concept that we got to die first before you do anything. And I was telling Sue that absolutely huge number of first-time buyers are being given money by their parents or their grandparents. And they can't buy without. So you might think about pre-giving. I mean, I always look at it that if you give the money to them now when they need it, it's much better than waiting. So, so just sort of think about that.
Are there
So,
you okay?
yeah, yeah.
Yeah.
So,
There's no tax implications for the recipient, right?
no gift tax, no,
Tax, okay.
no. So, sorry, I think I'm done. I think.
Yeah, well, thank you so much. I really appreciate that. Anybody before Jonathan goes have any more questions? Because he's fading. He may have to do it in sign language.
Yeah, go get my will. Excuse me.
Well, I really appreciate your time.
So welcome.
Jonathan, just so everybody knows, Jonathan's based in Scarborough, but he has offices that are in the Don Mills area and also in Whitby. But he does work all over the place. And he's just, as you can see, he's just a great guy, and his whole firm is very supportive for everybody. So I really appreciate that. Thank you.
Great.
Okay, bye. And before I let everybody go, I hope people found that useful and answered a few questions that you might have. I am going to just go back to my screen and see if I can bring this up again. So thank you all for attending. We're going to let you go a little early, the royal we. I just wanted to let you know that I do have another Zoom session next week, and I'll explain what that's about. It is two ladies that are in the kind of age in place sector. So one of the ladies, her name is Peg Bocci. She is a consultant. If you're interested in knowing what's involved in a retirement residence for you or for some family you may be taking care of, she's an independent person who helps people figure out where the best place is to go based on their location, their needs, and their budget. There are some services that do this. You may have seen some advertised called A Place for Mom. And those companies have consultants there, but they are generally under contract with certain large retirement home providers like Rivera or Amica. Peg is independent, and she will talk to you a little bit about what she does and a little bit about retirement living in general, so you can get an idea of that. And then I have Diane. She is with a health consultancy that provides age-in-place resources for people. So whether you need somebody to come in and help you, whether you need renovations to be able to stay in your home and all of that, her company is a one-stop shop for age-in-place resources that are more on the physical side of things, of how to stay in your place, how to maintain your living, and what that's all about. She has some special options for people that may have been teachers and things like that, where they may tap into some healthcare benefits that they didn't know about. So those two ladies are each going to do half an hour next Thursday, same time, same channel, different link. And then the last thing I wanted to tell everybody about is I'm organizing a community shredding event October 22nd, and I am bringing in a truck from Paper Savers. It's a mobile shredding truck. They are going to shred your unwanted and old tax statements, receipts, anything that you have that might have your personal financial information on it that you no longer need, like investment statements, bring them to the and they will shred them for you. It's completely free. I am taking voluntary donations and donating it to the community, Scarborough Community for Healthy Communities, and I'm going to match any donations that anybody brings. I am kind of setting a schedule so that not everybody shows up at the same time. It's between 10 a.m. and 1. So you can email me if you would like to participate. You can bring as much or as little as you want, and they're going to shred it on site so that they're doing it right there. You know that when you've gone away, it's all done securely. And that's it. Does anybody have any questions or comments? Everybody hear me? No, yes?
No question.
No questions.
Thank
Okay.
you.
Okay, great. Thank you so much for participating, and I'll sign off for now.
Thank you.
Okay. Thank
Thank
you,
you.
Sue.
Bye-bye.
Bye. And this is recorded. I'll send out a link.
Thank you.
Okay.
Yes. Oh,